More than 50 years after passage of the Voting Rights Act, there is still an ongoing battle over the ballot box. Some states, they've been trying to roll back access to the polls, and some even have been successful. And that is the subject of an upcoming book called The Voting Rights War. Let's welcome its author, good friend to the program, Professor Gloria Browne-Marshall of John Jay College of Criminal Justice. Professor, thank you as always for a few. I appreciate it.
Thank you.
Well, you know what? We can go long before that court case half a century ago. In fact, go back 100 years ago, 1915. I know you're right about this in the case, the grandfather clause, and how in many ways that set up some of the fights that we still see today.
Yes, I mean, that was the first case the NAACP, a very young organization at the time, took to the U.S. Supreme Court. The voting rights case in Oklahoma started it off with this issue of if the right to vote is supposed to be available to all people, then why is it that if their grandfather couldn't vote, these African Americans in Oklahoma and many other states were denied the right to vote as well? That and many other types of cases involving the literacy tests and others were obstacles put in the paths of people who truly want to be a full part of American citizenship.
And as you talk about, it's not just access to the ballot box in the broader sense. It's you had all-white primaries in places. You had limits as to who could even be able to run for office, right?
Right. There was even a law that a person had to indicate their race on the ballot when they ran for office, just to make sure that everyone knew the race of the person who was running for political office. I mean, there were so many obstacles to the right to vote and the lives that were lost in the fight. It was in the ballot box, but it was also in the boardroom. It was on the street. It was everywhere. The battle was ongoing.
Well, I want to get to a case before the High Court in a second, but certainly gerrymandering has impacted a lot of this conversation, and different parties have had their hands in it for different reasons, but at the end of the day, that and to a degree photo IDs, that have really led up to the case before the High Court now.
Yes, gerrymandering was something that took place not just in the South, but a great deal in the North. And that was to manipulate the voting districts so that certain political parties, or as we saw for a very long time, certain races, were unable to actually have their vote count. So no matter how many people lived in a certain area, for example, Brooklyn, it was gerrymandered in a way so despite this large black population, they could not have a U.S. representative in Congress, not until the 1960s and early 80s when cases were brought to challenge the districts in Brooklyn, and that gave rise to Representative Shirley Chisholm, who then went on to run for President of the United States, the first black woman congressperson. So you see how these things have to go through so many changes, lawsuits and such, before they actually result in some type of victory.
And then we bring up to the case before the High Court now, really centered around the premise of one man, one vote, and obviously impacted by the recent passing of Justice Scalia. Explain what's the root of the case, and just as a point of reference for the public, how this case is decided, if in fact there's a majority decision one way or the other. It'll involve how much rural, even suburban districts are going to have theoretically a lot more power than would suburban districts, and it would change a lot of the political map that we're finding not just on the state level but nationally too.
Yes, when we think about the right to vote, especially during a national election like this one, we think about President of the United States, but we don't think about all the ancillary actions that come from that election. I mean, we have to look at the district attorney, we have to look at mayor, but the president nominates the U.S. Supreme Court justices. That's in Article 2, Section 2 of the U.S. Constitution. So now that we have that power, you have to think, well, what's happening on the local level? Well, there are some people who believe that only the district with citizens should be counted, that population, to determine the number of congresspersons representing that particular area in the Washington, D.C., in the House of Representatives. So if you look at a city, you have lots more children, you have people who are ineligible to vote, for example, their former felony convictions or something like that keeps them, or mental health issues may keep them from voting. And so if you look at a very dense population in the city as opposed to a suburban suburban area or rural area there where you have more people, fewer immigrants, but more people who are eligible to vote. And you say, well, in counting the population, why don't we just count the population of people who are eligible to vote? One person, one vote. Therefore, the political power would shift from the cities to those urban and suburban areas where there is less of a population but more of a eligible voting population. And that's before the U.S. Supreme Court right now. 8 justices because of the passing of Scalia. That means, and it happened today, if it's a tie, 4-4, the lower court decision stands.
So if you think we've just been voting the last few years fighting over who gets to vote here and how they're counted, think again. The book again, The Voting Rights War, the NAACP and the Ongoing Struggle for Justice. Gloria Browne-Marshall, thank you so much, and take a look out, my friends, for that book. It's coming out soon. I appreciate the time.
Thank you.
All right, everybody, stay with us. We're going to take a look at some local headlines straight ahead.